Mr. Higgins, you have 4 minutes to make your case.
Thank you. I would like to thank the Cahirlook for selecting this issue and for the Minister for attending today in addressing the serious concern in relation to the proposed comprehensive trade agreement between Canada and the EU, CETA. There are of course many concerns in relation to CETA, the fact that it will apply to an unprecedented number of public contracts, including at local level, and the implications of that for the policy space in those contracts or services. The role given to the European Regulatory Council, which will have a mandate to privilege the least burdensome option in relation to regulation and has the potential to undermine present and future regulation in areas such as environment, employment or equality, issues highlighted as a concern by ICTU, by environmental lobby groups and by organisations such as TROCRA and indeed by many health organisations. The very practical concern that CETA was negotiated prior to Brexit and the removal of that large market of the UK from the EU could see, for example, Canadian beef exports redirected into other countries such as Ireland with a serious economic impact. However, my focus today is on the Constitution, and I am asking the Minister to assure the House that when he or another member of the government attends the Council of Ministers meeting in October, they will not sign up to the provisional application of CETA and will instead uphold Article 29.5.2 of the Irish Constitution, which clearly states the state shall not be bound by any international agreement involving a charge upon public funds unless the terms of that agreement shall have been approved by Dáil Éireann. Let us be very clear, CETA will involve a charge upon public funds. It would bring into effect, for the very first time in Ireland, investor-state dispute settlement courts, which could allow corporations to sue the Irish state for potential loss not only of present but of future profits. In other countries where such courts already operate, many settlements have run into billions. An ultimate blank cheque, which could, for example, speedily deplete the government's proposed rainy day fund. The Minister has previously, in reply to PQ's claim such trade agreements are not part of domestic law and that is why separate adjudication arrangements are required. However, any laws that are applied within our state must be tested for compatibility with the laws of that state and must moreover be tested to ensure they are not repugnant to the Constitution. Has the Minister, for example, spoken to the Attorney General in this regard? Moreover, is the Minister comfortable with the situation where Irish companies would work under Irish domestic law while international companies would have recourse to a new and different mechanism, a separate and particular advantage for them? I would also note that the current position held by the EU Commission in this is somewhat contradictory. They have, in recognition of the political situation, agreed to treat CETA as a mixed agreement, which requires EU Parliament and National Parliament approval. Yet, they still want signing and provisional application to go ahead of those political approvals being secured. And they have also reserved the legal opinion that the EU Commission has exclusive competence and said that they will wait and see the outcome of a case being taken in that regard at the moment in terms of the EU-Singapore deal. Would it not in that case therefore be prudent for the Member States and the Irish Government to wait and see themselves the results of that court case due next year before any signing or provisional application? This is recommended by many legal experts, including those from Client Earth. Moreover, with the court case recently launched in Germany on the constitutionality of CETA, widespread and glowing calls for a case to be taken to the European Court of Justice on the overall compatibility of ISDS mechanisms with EU law, would it not be inappropriate to be moving ahead with so many cases pending? I lastly conclude by saying this is not trade as usual. This has, by the EU Commission themselves, been marked as a milestone, the most ambitious trade agreement ever, a new generation of trade agreements. If we are in a new and experimental space where we are trying out new generations of trade agreements, does it not behove us to test them fully against our legal and parliamentary systems? And what signal does it send to the EU population at a time of growing and dangerous disillusion with the rule of law and with politics if states and EU bodies themselves choose to bypass legal and parliamentary process to short-circuit this particular trade agreement? Thank you very much.
Minister.